Good afternoon, Mr. Paul. Thank you very much.
My Lord, my Lady, just really by way of a roadmap to start. My learned friends have not addressed orally before the board grounds 2, 3, 7, 8 and 9 on conviction. I readily understand that they are not abandoned, but the way I propose therefore to deal with them is to leave the board with the respondent's answer on paper in the written case, and simply, when I come to those grounds, refer the board to where that's dealt with on paper, perhaps by making some additional submissions on the proviso point, which is ground 9. That therefore leaves on conviction, the focus of my submissions is going to be first ground 1, the fairness of trial ground, if I can put it that way, focusing though on the withdrawal of Mr. Seymour and the impact that that had on the trial, especially as regards the cross-examination of Miss Davis and the admissibility of Dr. Reddy's evidence. That will then lead into me addressing the board on grounds 4, 5, 6, which really focuses on Dr. Reddy's evidence and the admission of the confession statement. I hope I will be forgiven when addressing ground 1 of giving the board a number of additional transcript references in support of my overarching answer to ground 1, the fairness point, which is that when one looks at the transcript of the trial in the round, I say that the appellant was afforded a fair trial. And in particular, I say there were a number of steps taken by both trial judge and Crown Counsel to assist the appellant. And also, I say it is clear when one looks at the transcript in the round that the appellant was able to advance a clear and cogent defence. And so I will, these are dealt with in the respondent's written case, but there are a few additional references that I'll take the board to. And I do say that the characterisation that the appellant makes of the trial as one, effectively, of a judge rushing an unrepresented defendant through a murder trial because she had other commitments. I say that is unfair and is not borne out when one actually looks at the transcript and what happened at trial. So dealing then with ground 1, the gravamen of this ground is the withdrawal of Mr. Seymour. But certainly in the written case, it is also a complaint made about the disclosure or lack of disclosure or lateness of disclosure. We respond to ground 1 in the respondent's written case at paragraph 7 to 41. We break that down at paragraph 7 to 26. I make some general observations that point to, I say, the appellant having a fair trial. And then paragraphs 27 to 41 deal with the appellant's specific complaints. And what I propose to do, before I deal squarely with Mr. Seymour's withdrawal, because I say it rather sets the scene for that, is just deal with the disclosure complaints, but bearing in mind they didn't feature in my learned friend's oral address to the board. So I'll take them briefly and simply refer to where we address them in the written case.
Mr. Paul, the board, unless counsel abandon something something they've said in their written submissions, will take them into account. And I think the basic approach which you're adopting, which is answering most of them through your own written submissions, is absolutely fine. But clearly, if you want to bring out further points, then Mr. Fitzgerald and Mr. Lundy in reply can answer them.
Yes, I'm grateful. That's the, how I intend to proceed. So the point on disclosure, we say, is the prosecution complied fully with its disclosure obligations, and we say you can in fact see that from the transcript because there was an order for disclosure made at an earlier case management conference on the 11th of May 2012, so a year before the trial started, and the trial judge in fact made that order, and the trial judge remarks in this trial that the prosecution complied with that order. The reference for that is volume 1, 45 to 46. There are some specific complaints made in the appellant's written case at paragraph 11, and the reason that I want to just expand on what's said in our written case in response is because a number of them are submission wrong as a matter of fact, but also they inform the submissions I wish to make about the fairness of the trial. So the first complaint that's made at paragraph 11 is that evidence of a previous theft and use of the appellant's mobile phone, a copy of a police report was not provided to the appellant. Now that is wrong, and we can see that from the record, and the references for that are volume 2, page 760, and volume 3, page 955. So not only was a copy of the police report given to the appellant, but in fact Officer Miller, who was the officer that the appellant made the complaint to, gave evidence and was cross-examined about this, and that starts at volume 3, page 949. The second specific disclosure complaint that's made is that the BTC mobile phone records were not made available to the appellant despite him requesting them. Again, I say that's not correct. In fact, records from 4 different mobile phone numbers were made available to the appellant because the board will see that a significant part of the appellant's defence relied quite heavily on mobile phone evidence. His case was effectively that the mobile phone that received minutes from the deceased's mobile phone, which sort of put him on the Crown's case, certainly, or put that mobile phone at the scene of the crime, the appellant says that mobile phone had been stolen from him, and moreover, that mobile phone, when he got a replacement SIM, was regularly used by Zena Davis. And that is really the main part, and that's what he cross-examines Zena Davis on, and I'll come to that in a moment. But the importance of the mobile phone records was not lost on the Crown or the trial judge, and there was a subpoena granted during the course of the trial. And Mr. Green from BTC came to trial as the appellant's witness, along with the records of those 4 mobile phone numbers. The appellant was given time to speak to Mr. Green before he gave his evidence, and the reference for that is volume 3, page 1031. And I say that his cross-examination of Mr. Green is a good example of the appellant effectively putting forward his defence. Because
it would be examination in chief, presumably.
I think there was leeway given. It should obviously have been examination in chief.
But it wasn't technically a cross-examination.
No. And that is at volume 3, page 1098. And if the board looks at that cross-examination, it is a detailed cross-examination arising from quite complicated phone records. And he elicits from Mr. Green helpful evidence as far as his defence is concerned, that, for example, Mr. Green accepts that he would not have had to be in physical possession of the phone at the time for the minutes to have been transferred.
Can you just help on the facts, please? I'm not sure I've got the picture.
Yes.
You said that his case was that the mobile phone that received the minutes was stolen, and then you went on and said, and when a replacement SIM was obtained, it was registered, it was regularly used by Miss Davis. So I just wanted to be clear.
Yes. So there were 4 relevant mobile phone numbers in this case. There was a mobile phone number ending 7092, which is the number that the appellant gives to the police when he reports his phone stolen. And that number is the number that the appellant gives to Davis when they first meet. And there's a reference to that, volume 158. So that is, even on the appellant's case, unquestionably a number registered to him. There is a second number that's registered to him that ends 9764. That is the number that the deceased's minutes are transferred to, and that is the number that he says, the appellant says, first was stolen and was subject of a police report that I've just mentioned. And when he obtained...
Sorry,
I thought you said 7092 was stolen.
No, sorry, Michael. The 7092 was the number. So when he reports his phone stolen to the police, he gives 7092 as his mobile number.
Oh, I see.
Sorry. So that's just, sorry. So that, the reason I said that is that's how, from the transcript, we get evidence that the appellant effectively does not dispute that 7092 is a mobile number.
It's the one he's using. He gives
yes,
it as the one he's using.
Absolutely.
Yeah.
So it was the number given to the police when he reported that
Yes.
another phone was stolen?
Yes. And the phone that he reported stolen was the second number that I've just given the board, 9764.
Thank you.
And the reference to the replacement SIM is that he gets a replacement SIM for that phone, keeps the same number, but it is that new phone, new SIM, same number that his evidence is that Zena Davis would regularly use.
So in another casing, but the same telephone
Yes,
number.
Same telephone number. The third relevant number that is associated with the appellant is a number ending 9551. And the evidence from the phone company BTC is that that is an unregistered prepaid phone number. And this is listed by the appellant in his cross-examination of Mr. Green. The reason that the appellant says the reason that is relevant is because that is the number Zena Davis says contacts the deceased. So the appellant's defence through this cross-examination of Mr. Green is effectively the number that Ms. Davis says contacts the deceased. That could be anyone using that, because that's a prepaid, unregistered phone number. It's not a number that's registered to me.
Has anybody got the deceased's phone record?
Yes, they were. So the fourth, I said the four relevant numbers. Deceased's phone number ends 1561, and those four numbers, the records for those four numbers, were provided to the appellant, and he examined Mr. Green about those records.
And they were provided to him when?
They were provided to him from it. The subpoena, initially the judge thinks that BTC are just going to hand over the records without a subpoena. It then becomes apparent they're not. The judge issues a subpoena, and I think there or thereabouts, day 13 of the trial, the records are provided, and Mr. Green attends court. The appellant is given an opportunity to speak to him, and then he cross-examines him.
You say in your case that the deceased records were disclosed before the trial.
Yes, I think that is right. And then when it became relevant, when the trial judge became aware that the defendant placed a lot of store by these other records and wanted these other records, then a subpoena was issued to get these other records. So by the time Mr. Green gives his evidence, the appellant is in possession of records for the relevant period for all four mobile phone numbers.
But one of the things that immediately springs out of what you've just said is that somebody would want to check whether the evidence that Zena Davis had given about the 95551 being the number that contacted the deceased, whether that was actually replicated in the records.
Yes, and that's what the appellant cross-examines Mr. Green about, because he does a
tally of the
very
two.
good comparison between outgoing numbers and incoming numbers to the phone, using the phone records.
But did he have the records in time to cross-examine Zena Davis about it?
No, because all he sees from his cross-examination of her, all he wanted to elicit from her is her confirming that she used the number that he said that she used. And she confirms that in cross-examination, and he asks no further questions of her on that. So she confirms that she would use the 9764 number.
And I'm so sorry to be catching up. The transferred minutes are to the 9764
From the deceased's phone.
number. And is that with the replacement, is that to the replacement SIM then? We don't know.
We don't know is the answer. If all the records show is that it's to that number. So the evidence was that minutes were transferred from 1561 to 9764 in 1:36 a.m. 20th September 2009 in the sum of $4.25. And Mr. Green gives evidence as to practically how that takes place.
And did I understand you to say that Mr. Green accepted that it would not be necessary to be in possession of both phones at the same time in order
yes,
to do
so initially his evidence is when he's asked the question, would you need the phone of the deceased to make that transfer? And he says yes. He's then, whether it's examination in chief, I think this may now technically be sort of re-examination, but he's certainly asked by the appellant whether that's right. And the question is effectively, do mistakes happen? And Mr. Green says yes, they do. And I think what the appellant is listing is the fact that you don't have to have physical possession of the phone in order to effect a transfer from one phone to the other. And Mr. Green accepts that.
The phone could be anywhere.
Yes, I think because of how the mechanism, how the minutes are transferred, you can contact BTC and ask them to transfer, I think is really what Mr. Green is saying. And the judge in his summing up makes this point and reminds the jury of Mr. Green's evidence that you don't need to be in physical possession of the phone.
But I recall Mr. Green's statement that mistakes happen, but I hadn't read that as going back on his previous evidence that you needed to be in possession of both phones. I thought it referred to the records.
The reference I had for that was volume 3, 1101. It's 21 to 25.
Sorry, 13.
So volume 3, 1101.
Thank you.
Ask the question, so in order that doesn't mean that Simeon Bain was actually handing that phone and transferring that minutes from the deceased phone to his phone, which is in his name. And Mr. Green says not necessarily.
But is that because you'd have to phone the phone company and ask them to make the transfer?
My lord, that was certainly my understanding of the evidence, and I will.
I mean, he first of all asks if mistakes are made in transferring the minutes to the wrong phone.
Yes.
So yes, and that means so if you make the transfer, then you phone the phone company saying, "Please, will you transfer it back?"
Yes, I think that's
the mistake.
That's the mistake.
But the judge certainly understood the answer to be you don't have to have the physical phone.
That's certainly how he summed it up to the jury as a sort of point made by the appellant in questioning Mr. Green. And just to put in
1239 of the summing up. Ties into the confession statement, doesn't it? He says on the previous page.
Yes, my lady. Yes, that's what the appellant said in his confession statement.
Yeah.
And obviously what he wanted to achieve by having the records and obviously undermine that part of the prosecution case that scene of the crime, or put that phone at the scene of the crime.
Bit on 1239. It doesn't respect Zena Davis's concession that she was the one who used the phone, or that she did use that phone.
But I'm fairly confident there is a... If I can find the reference that I'm thinking of in the summing up, I'll
Line 28 of 1239. Judge seems to be saying Mr. Green's evidence was that you did have to have physical possession.
Yeah.
later. Definitely the judge reminds the jury of the... So what I had in mind is 1256 at the bottom, where the judge is reminding the jury of this line of cross-examination about Mr. Green saying that people can make mistakes when transferring. Phone to another. Just to bring the board back to the context in which making these submissions about the mobile phone, it's really to meet a complaint which I say is unfounded, which is that the appellant was not provided with the phone records. And I say not only was he provided with the phone records, but he was able to effectively cross-examine Mr. Green about it. And it's quite an important part of how he saw his defence. And in fact, this does inform, when I go on to make my submissions about Mr. Seymour's withdrawal, it does appear that an aspect of that related to Mr. Seymour not having requested earlier the phone records. But I'll come on to make those submissions and give the Lords and my lady the references at that time.
Could I just ask, was 1561 the deceased number? Was that the BlackBerry?
Yes.
Thank you.
Yes.
Yes.
The final specific disclosure complaint that's made, and this was in fact developed orally as well, the lack of any evidence about Miss Davis's custody record. Now, Davis's evidence was that she was not arrested in connection with this offence, and that evidence is Volume 1, page 190, lines 11 to 16, and that she was not in custody when she gave her statement to the police, and that's at Volume 1, page 197. As to her cousin, Miss Colmer, she was in fact proposed to be one of the appellant's witnesses, and the appellant was permitted to contact her during the trial, and she confirmed, well, they spoke, and then the appellant confirms to the judge that he no longer wishes to call her as a witness, and that's Volume 3, page 976. There is a point made by the appellant about late evidence. We deal with this in our written case, and I just give the board the references. The only so-called late evidence were notices of additional evidence, which were served 8 days before the trial. There's a suggestion by the appellant that they didn't have any notice of this until the actual morning of the trial. That's wrong, and we see that from volume 1, page 41. And those notices of additional evidence were simply chain of custody for the surveillance footage at Burger King. And Mr. Seymour, whilst he's still acting, realistically, in my submission, concedes that there's no real prejudice, as he would have expected the prosecution to call witnesses to put in the surveillance evidence. And we see that from an exchange at page 46, volume 1, lines 28 to 32.
Sorry, reference again, please.
So volume 1, page 46, lines 28 to 32. There's a point that my friend, in fact, started his submissions with this morning, which was about the education of the appellant. And I just briefly want to give the board some references, because I do say that the defendant was able to represent himself. And we see from the transcript that he confirms that he could read a little and understand what is written. And that's page 191, volume 1. There's in fact a discussion at volume 2, page 572, about the defendant's education. And it is put on the basis that the judge asks him to confirm that he reads the Bible and all kinds of books. And he confirms that. We know from the transcripts that the board has that, in fact, the appellant was provided with transcripts of the trial at the end of every day, and if not at the end of every day, certainly before the weekend, so that he could read them and prepare cross-examination. The reference for that is volume 2, page 688. My lord and my lady have my point about the BTC phone records. I say that shows quite clearly that this was a man that was able to assimilate written information and formulate appropriate questions, having reviewed it. He's referred to by the judge as doing a good job during the trial. It's volume 3, page 1016. As an intelligent person, volume 2, 698. And the submission that's made, for what it's worth, by prosecuting counsel in the Court of Appeal is that no other counsel could have presented his case better. Now, I'll come on to Ms. Davis's cross-examination, but I say that was the impression that the judge formed and the prosecuting counsel formed at the trial. Next point, again, that was developed orally by my learned friends, that this was a rushed trial, and I do say that that is unsustainable when you look at the transcript. First of all, the judge ascertains the views from both counsel as to how long the trial is going to take. And both counsel agree it shouldn't take longer than a week. And despite that, the judge allows 9 days, in her words, to be on the safe side. And that's volume 1, page 18. When the appellant is given an album of photographs, to look at, of the post-mortem photographs.
Sorry, but that's an estimate, is it, assuming the appellant is represented?
At that stage, my lord, yes. When the appellant's given a photo of album photographs to look at, there is an adjournment to allow him to actually look at those photographs. Volume 1, page 75. During his cross-examination of Davis, during the voir dire, the judge tells him to take his time, and she says she is in no rush at all. That's volume 1, page 200. After the end of the prosecution case, the judge adjourns for a week and notes that although she had hoped to start her next case, she must give the appellant a fair right to call his witnesses. That's volume 2, page 751. Before closing speeches, the judge gives the appellant time to prepare. in volume 3, page 880 to 881. And when the appellant says that his closing is going to be a little lengthy, the judge says that they will therefore start the following day and that there is no restriction on length. Volume 3, page 1102. I say that there are also a number of references in the transcript to allowances being made for the appellant representing himself, and we deal with these paragraphs 17 and 18 of the respondent's case. And I've noted at least a dozen, and I don't propose to take the board through those. Just perhaps by way of some representative examples, I've referred to the album of photographs. The judge removes 2 photographs from that album on the basis that they are prejudicial, and she notes when doing so that she's dealing with an unrepresented defendant. And that's volume 1, page 70. When Ms. Davis is giving evidence, the judge checks that the appellant understands the purpose of her giving evidence, because this is during the voir dire, and gives him time and asks him whether he wants a cup of tea, and explains that she wants to be able to help him better. And that's volume 1, page 201 to 203, is that exchange. The appellant is permitted to sit when he's cross-examining Officer Hall. The judge makes, at volume 2, page 712, the judge notes at volume 2, page 868, the assistance that is being provided to the appellant. And perhaps an important and arguably stand-alone point, because there is a criticism made in the appellant's written case, is that the appellant was effectively left to his own devices and had to do the best he could in terms of calling witnesses. And the point being made, well, how could he do this? He was not represented. He didn't. The judge and the prosecution, in my submission, went above and beyond in terms of taking steps to help locate, identify, and ensure that the appellant's witnesses attended trial. And that doesn't just go to the BTC phone records and subpoenaing Mr. Green. There is a discussion about the appellant wanting to call 7 witnesses at volume 2, page 495. The judge then confirming that the appellant should be given facilities to make phone calls to contact those witnesses and secure their attendance. And that's at page 692 in volume 2. And 4 witnesses attend trial on behalf of the appellant, and we've heard Miss Colmer, the appellant decides he doesn't want to call, and they can't get hold, despite all their attempts to get hold of Miss Colmer initially, and then there is a subpoena issued, and then, as I said, the appellant speaks to her by telephone and then confirms he doesn't want to call her. Do make the submission that the appellant presented a clear and cogent defence. The Court of Appeal, in paragraph 24 of their judgment, page 1790, which is volume 4, they described it as pellucid that the appellant was able to aptly put his case, having gone through the transcript.
Critical to the defence was to seek to undermine the credibility of Davis.
Well,
There doesn't seem to be much.
No, and if I was going to say I'll deal with that when I come to Mr. Seymour, but I'll deal with it.
No, whenever suits you.
Well, if I may, I'll deal with it because it ties in really with Mr. Seymour's. I do say, and this is if you like the final point before coming to Mr. Seymour, just on general fairness, the board should, as the Court of Appeal did, consider the strength of the prosecution case when considering the issue of fairness. And have this, we do at paragraphs 25 and 26 of our written case. And perhaps the only point to add to what is said there in writing is a point that would not have been lost on the jury, which is not only did you have the confession, but the confession contained a lot of detail that no one else but the appellant would have known. And the appellant realised that this is a difficulty for him because his explanation for it was that he did volunteer parts of that confession statement, and then there were parts of it that were sort of effectively written for him by police officers. And so, for example, and this is the point that's made in the prosecution's closing submissions, the confession refers to the appellant driving the deceased in the boot of his car to an abandoned warehouse. And the appellant in his cross-examination explains that that was an abandoned warehouse that he knew about because he would take women there. So his case had to be that he made up certain parts of the confession and then the police made him say other parts of the confession. But I say that would be a point that would not have been lost on the jury. Moving then to Mr. Seymour's withdrawal, and before I look at Robinson and deal with Mitchell and Dunkley and the case of Maguire, I think that there are 3 points to make based on the record and what happened at trial. And I say first, the appellant chose to represent himself. I do not accept that it is a fair reading of the transcript, what is said at paragraph 28 of the appellant's case and what Milena Friend has made in all the submissions this morning, namely that Mr. Seymour was sacked because that was the only way the appellant thought he could get copies of the prosecution. I say that that's not a fair reading of what happened, and hopefully I'll make good that by a couple of references that my lords and my lady have not yet been taken to in the record. I say it's clear that Mr. Seymour was sacked because the appellant had lost confidence in him and did not think he was representing his defence the way he wanted it to be represented. Now, the first reference is one that the board does have, which is, and my Lord Lloyd Jones drew attention to this, which is the "I'm not competent." He insists that it must be done his way, which is volume 1, page 52, line 25, which I say does speak for itself, although it's in the context of a discussion about obtaining documents. There's a reference, though, later on, in volume 1, at page 283 to 284.
But sorry, just on that.
My Lord.
I mean, it's very difficult for us to work out quite what's going on there. I mean, shouldn't the trial judge have explored further what the difficulty was to see if it was possible to overcome it?
I agree that it's difficult just looking at the transcript. I say the judge, from what the judge said, it is clear that she understood that there had been a fundamental breakdown between Mr. Seymour and the appellant. And in my submission, that is why she, as it were, readily accepts Mr. Seymour's withdrawal.
So, sorry, are you saying she'd explored this before and was entitled to come to that conclusion?
All I can say is that I say is a fair reading of the transcript. That there had been, she was treating it. I can't say that she explored this before because there's no reference in the record. But I say from the way that she accepted the withdrawal and the words that Mr. Seymour used, which is "I may not be competent," she must have accepted that there was a fundamental breakdown between the appellant and his counsel.
Right, but if she didn't have anything to go on, was it right for her to make that assumption without exploring further what the position actually was?
Well, we accept in our written case, as did the Court of Appeal, that more could have been done to impress upon the appellant the risks associated with him deciding to represent himself. And I
wasn't thinking so much actually about the appellant as about Mr. Seymour, to explore with Mr. Seymour just what the difficulties might be and to remind him of his duties to his client and see whether there wasn't some way forward which would involve him continuing to represent the appellant.
For example, asking specifically, can't you just give him a copy of the documents?
My lady, obviously, with the benefit of hindsight, the judge could have done that. But I say when one reads this exchange, and it's quite a long exchange where the judge goes out of her way to remind the appellant that this is he's got experienced counsel formerly in the police force, and that's the references at the bottom of page 52. Effectively, she is impressing upon the appellant to think long and hard before going down this route.
Right, but that seems to culminate on page 55 in the passage we were shown, where the accused seems to have it in his mind that the only way he's going to get a copy of the material himself is if Mr. Seymour isn't representing him.
My Lord, there does appear there to be more to this than meets the eye, where we see where it says Madam DPP at the bottom of page 55. So the prosecutor says, my learned friend came to me this morning, made certain indications to me, and I on his behalf asked for an adjournment. I saw this coming, I really saw it coming. And then over the page, because in other words, so reading at line 9, but because in other words he seems to be dissatisfied with the service of my learned friend, that is what it amounts to. Not like my learned friend for any usual allegations that accused persons make against their defence lawyers of incompetence to come to my learned friend in this matter. I know the difficult circumstances under which he has put himself to appear for this accused. So,
It all seems to be sort of hints and inference. I just question for myself whether it's a proper basis for the judge to proceed on the basis of hints and inference rather than actually trying to get it so far as she can, because I appreciate there will be questions of privilege and so on, to what the real root of the difficulty is.
Well, I accept there was no direct question asked of Mr. Seymour.
Thank you.
Can you tell me why you feel it necessary to withdraw?
Well, it's very difficult in a criminal court for a judge to ask that question for fairly obvious reasons.
It does appear that code is being used here, and I can understand because of questions of privilege.
The prosecuting counsel is doing, in my submission, as best she can to indicate to the judge that there's been discussion between counsel where Mr. Seymour has outlined difficulties that he's in, doesn't feel competent to carry on. And in my submission, that's why the judge does not press the matter any further than he actually did. But I do accept that what the judge perhaps should have done is then outline to the appellant the risks of going down this route, representing yourself.
So you say he chose to represent himself, but did he make that choice aware that alternative representation might be coming to us?
Yeah, only really to make, if I can just give you 3 references that I say underscore my submission that this was a decision, a positive decision taken by this appellant because he had lost confidence in counsel. And then I'll come on to the alternative representation point and whether that is something that this appellant would have also taken up had he been offered it. So just these 3 references, volume 1, page 283 to 284, bottom of 283, the report says, that is why we gave you a lawyer for that very reason. And the appellant says, he never asked for anything. He never, I write it down for him to ask in case management for certain information. He never asked for the information. So there's an obvious dissatisfaction that instructions are not being complied with for certain information that the appellant sees as important to his defence. And this is a continuing theme, because if we look in volume 3, page 912 to 913, the appellant is asked a question. I asked you a simple question. This is the judge. I asked you a simple question. Did you relieve Mr. Seymour of his duties because you felt that he was not defending you adequately in a manner you wished to be defended? The appellant says he did not ask for certain things that I asked him. You didn't answer what I asked, a simple question. Did you relieve him of his duty because of that? The appellant, yes, I fired him, my lady. Yes, you fired him, and on what ground? Because he didn't request certain information that I asked him for. Plus, he wanted me to sign some papers that I did not understand.
Did the judge seem happy enough to explore things then? I thought you were telling us that that was something that was inappropriate for her to do.
Well, my lord, I think this is prompted by the exchange that she's therefore having with the appellant. And she goes on to say, just to finish this passage, I spoke to you about the dangers involving you not being not having, I assume, a lawyer conducting his trial on your own, but you said you're prepared to go ahead with your trial, okay. And then the final and perhaps definitive reference is later on in volume 3, 997. And this is perhaps really getting at the heart of it. There was an earlier reference to Mr. Seymour having previously been a police officer, and that was something that the judge alluded to at the beginning of the trial. And here, at the start of the appellant's cross-examination of Mr. Seymour, he starts off with a line of questioning about that. And at the bottom of 997, he says, Mr. Seymour, can you tell this court where did you work before you became a lawyer? And it's asked, what's the relevance of that? And then over the page, the relevance of that to this case is Mr. Seymour didn't put his best effort to represent me. Judge, Mr. Bain, hence the reason why Mr. Seymour no longer represents you. You came to that conclusion. Then that is why I had to fire him. I had to fire him. So it is my submission fairly clear from that exchange and the proposed line of questioning was shut down. Is that the appellant did not like the fact that Mr. Seymour had previously been a police officer, given his defence was one of being set up by a combination of the police using, he would say, a sort of forced confession forced evidence of a statement from Miss Davis. So I do say this is a case of the appellant choosing to represent himself, and then in answer to my Lord Hamlin's question, the procedure would have been for there to have been an adjournment to explore obtaining alternative counsel. I say it is quite clear, though, that this appellant wanted to represent himself. And the reason I say that is there's an exchange that we see in, so it's volume 3, 1298. There is evidence, this is during the sentencing hearing, from the probation officer, where he records that the appellant prefers to represent himself. So it's volume 3, 1298. Line 26, Mr. Bain demonstrated an understanding of the legal system, appropriately understands the concepts of sentencing, understands he's entitled to public defence, but he prefers to represent himself. I do say, in the absence of any contrary evidence, the board shouldn't accept the submission that certainly is made in writing in its paragraph 42 of the appellant's case, which is effectively, had the appellant been offered alternative counsel, he would have accepted it, is what said at paragraph 42 of the appellant's written case. I said the board should be very hesitant before accepting that, given the probation officer's evidence, but also in the absence of any evidence from the appellant.
Surely he should at least have been offered that. What would you say about that?
My Lord, I repeat the point that we made in our recent case, which is we accept, as the Court of Appeal did, that more should have been done by the trial judge at the time.
They accept more time should have been given. They don't ever address the representation issue. But you accept, do you, that that should have been explored?
I accept that I think I go as far as the Court of Appeal go in the judge should have explained to the appellant the risks of representing himself in a murder trial and what that entailed. Ultimately, the question of whether there should have been an offer of alternative counsel, in my submission, goes also to this question of prejudice, which is what I draw from the case of Robinson, which is, did the appellant representing himself cause him serious prejudice? And that's why I draw on the general submissions I've made already about the fairness of trial and the ability of this appellant, and I'll come to the cross-examination of Davis in a moment. But I say, when one looks at the course of the trial after the appellant elected, Mr. Seymour withdrew, or the appellant decided to represent himself. When one looks at the course of the trial, this appellant suffered no prejudice as a consequence of that. And I do say that is the appropriate test from the case of Robinson, which the board has at tab 21 of the, I think it's volume 1 of the authorities bundle, 2310. And
You say the test is?
whether there has been miscarriage. I said prejudice, whether the appellant has suffered any serious prejudice, but it equally it could be said, has there been a miscarriage of justice as a consequence of the appellant representing himself? And one has to look at what happened in the trial, point to. And I think this isn't controversial. I think the appellant accepts that it's not good enough to say this is an appellant that represents himself, therefore this is an unsafe conviction. You must go further and then identify the prejudice and why there is unfairness. And so I say Robinson supports that as a proposition. And what Lord Roskill said at 9966. So this is in electronic page 2310 is the start of the case, and the relevant passage at 2320. And the top of 2322, their lordships therefore turn to consider whether, as a result of the absence of legal representation, there is any risk of a miscarriage of justice having occurred. They have approached this question with great care, mindful of the difficulties which any person defends himself necessarily encounters, however fair, courteous and helpful to trial judges. And I say that's the position we're in here. And so there's nothing that's said in the subsequent cases of Mitchell and Dunkley where the board has considered this question that is contrary to what is said there. And I say this is a case where the appellant was ready, willing, and able to conduct his own defence, and was even offered an adjournment and turned down the adjournment because he felt he was able to continue without
Was he offered an adjournment?
He was offered. So when it was confirmed that Mr. Seymour withdrew, the prosecutor, page 60, volume 1, page 62. So the Madam DPP says, before you drew him during my lady, you may have just for the record inquire whether he had received all his documents. And then just skipping down a few lines to line 12. Court would perhaps consider allowing the accused an opportunity to look through those documents that he just got today. I'm just raising it, my lady, because I thought about it during lunch adjournment, and then the judge says it did occur to me also. I don't want it to be said that he did not have adequate time to prepare his defence, just having received his documents today. So I rise to just assist the court in this regard. But my lady, I would say, no, it goes on, and over the page is then the exchange where it's put to the appellant. line 9, nature represented, got the file from your lawyer today, are you well prepared now to continue the trial? And it says, I'd like the trial to go on. You want the trial to go on? Yes, ma'am. And then at the bottom of the page, 7, are you sure you don't want me to adjourn this case to start tomorrow morning to give you a bit more time? No, ma'am. Go ahead. And then, in fact, what happens is that the first witness that's called gives evidence putting in some photographs. And it's not until the following day that there's any real cross-examination for any witnesses in any event. What the appellant points to as the sort of unfairness with this appellant being unrepresented is twofold. It's the cross-examination, ineffective, they would say, cross-examination of Ms. Davis, and proper submissions not being made that could have been made about Dr. Reddy not being in attendance. So I'll deal with those next, if I may. I accept that Ms. Davis was not cross-examined extensively, and the board can see for themselves the extent of the cross-examination. It is, though, to be contrasted with the cross-examination of her during the voir dire, although again, I take Lord Roger's point. Ms. Davis was called by the appellant during the voir dire because he believed that she would support his account of being beaten, which during the voir dire she did not. She didn't even descend in the voir dire to give evidence about seeing him on the floor. And his cross-examination of her during the voir dire is fairly extensive. It's volume 2, page 462 to 474. And it's fair to say he makes very little headway in cross-examination of her, but positively puts to her on numerous occasions that she is lying, which she denies. It would appear that when it gets to, actually pausing there, on the question therefore of the admissibility of the confession statement, which is ground 6, one has to separate the impact of Miss Davis's evidence, because there is, I say, effective cross-examination of her on the question that is at the heart of that voir dire, which is oppression. So I do say, and this is addressed in paragraphs 54 to 59 of our written case dealing with ground 6, that the judge was right to admit the confession statement. And Miss Davis's evidence, or her confirmation that she didn't see the appellant being beaten, but was but one part of the evidence that the judge had before, to 2 police officers confirming that the appellant wasn't beaten. Miss Davis saying she didn't see the appellant being beaten, and then Dr. Reddy. It would appear, though, by the time it gets to trial, the key point that the appellant wishes to focus on, again, is the mobile phone evidence. And he cross-examines Miss Davis on her use of the mobile phone that he said she would regularly use. And she confirms that she used it, and that's volume 2, 874 to 875. It is not put to her, again, as no doubt it would have been had counsel been representing the appellant. She was lying. Statement about everything that she said she saw on the night in question and about the conspiracy. The jury, in my submission, would have been left in absolutely no doubt that that was the appellant's case. So this isn't a case of it not being put and therefore the jury not understanding the nature of the defence. And they heard her evidence and they heard the appellant's evidence, and they would have weighed both up. Which I accept without her evidence being tested by the appellant on this question of credibility. But the reason I say they would have been left in no doubt of what the appellant was saying, if I can just give some references. The appellant's closing speech, volume 3, page 1130, he makes it clear that the issue is whether or not the jury accept that Davis is speaking the truth, is how he puts it. In the judge's summing up, there are repeated references to the defence being the appellant was framed, and we see that this is all in volume 3, page 1205, 1236, 1239. The judge refers to the appellant saying he's being framed as Davis had the phone, so specifically referring to the appellant's case that Davis was in possession of the phone at the relevant time. Framed and surveillance had been manipulated at 1263, and then again a reference to him being framed at 1264. And then the judge reminds the jury that the appellant says they should not believe Davis at page 1221.
Sorry, page
1221.
Thank you.
And that the appellant paints Davis as a liar and invites you to reject her testimony, and that's 1223.
In a sense, that highlights the problem of making submissions like that when no groundwork's been done in the evidence.
The reason I draw it to the board's attention is really to make the point that the jury understood that this was an issue that they had to resolve, but I accept that there was no testing of her evidence on this issue of credibility. The judge did, however, point out that the jury were the sole arbiters of fact here, and that they do not need to believe even unchallenged evidence. Perhaps, yes, a standard warning, but in a case of this nature, a salutary warning to the jury, or direction to the jury, and that's at 1201. They don't need to believe even unchallenged evidence. Second aspect of unfairness is Dr. Reddy's evidence, and if I may, because that is grounds 4 and 5, specifically grounds 4 and 5, although it also then merges into ground 6, which is the confession. So if I, before moving on to grounds 4 and 5, just give the board the references to where we deal with grounds 2 and 3. Ground 2 is the complaint about proceedings being brought by way of a voluntary bill of indictment. We respond to that at paragraphs 42 to 48 of our written case. Ground 3 is the lack of a Turnbull direction. We respond to that at paragraphs 45 to 48. And then rounds 4 and 5, Dr. Reddy, we deal with at paragraphs 49 to 53.
The identification on CCTV was quite an important point, wasn't it?
It was obviously part of the prosecution's case. Yes.
Because it was fairly graphic what was shown on CCTV, so if it was him, that's really good.
Yes, but the issue was not one of, in my submission, identification or accuracy. It was one of veracity. The facts are that Davis knew this appellant well. She had lived with him for several months before this incident and had continued living with him after the incident. And the issue, therefore, for the jury was not so much whether her identification through the surveillance of, based on clothing and build, was accurate, but whether she was in fact telling the truth. And there was no attack on the accuracy of her identification. And I do say that this is one of those cases where a Turnbull direction not only would have added nothing of substance to the jury directions, but might well have confused the jury. It's one of those cases. It's
Blurry footage, you couldn't see his face. She was just going on build and clothing.
yes.
So it's not the sort of case where there might be some... It needs to be exercised.
I say no, given the issue, as I said, was not an attack on accuracy. She was very clear what she had. Her evidence was very clear what she had seen the appellant wearing when he left that night with deceased, and she confirmed that is what was shown on the surveillance footage.
I thought there was a difference between what she initially said she'd seen him wearing and her then confirming that the person dressed all in black on the CCTV footage was wearing the clothes she'd seen him wear. Because there was the passage in her evidence where she talked about him wearing a beige top. Sorry, I'll find it. So it's page 185 is after she's seen the CCTV footage, lines 14 to 16. How do you know that is Simeon in back? Because that is the same clothes I saw him leave in. But I thought, am I wrong in this, that the CCTV footage showed someone dressed in black? Whereas page 169, she talked about him wearing a beige shirt, white tennis shoes. Oh, sorry, I'm inferring white tennis shoes, white tennis, and gloves, beige gloves.
So white shoes or black shoes? Is it, yeah, black shoes.
Well, it's a black jeans jacket, black jeans pants, probably a beige or so shirt with white tennis, I think, some white tennis, gardening gloves.
Yeah, I must admit, and I'm not saying my law says...
Sorry, I could be wrong, but I thought there was...
I didn't understand it to be said, based on my reading of the transcript and also what the appellant says, that for there to be
All right.
any difference between what she said he was wearing when she saw him leave and what she saw on the surveillance. I think that the appellant's point is that she starts off looking at the surveillance saying it's all a bit blurry, but I think what it boils down to is that she then confirms that what she sees there is what the appellant was wearing when he left, and also he's the same build as the appellant.
Yes, all right, thank you.
Where's his cross-examination of her about this CCTV footage?
The appellant's cross-examination of her.
Miss Davis about the CCTV.
My lady, as I said, there was limited cross-examination of her, and really the only cross-examination of her is to the mobile phone evidence.
So there's none of what you'd expected of it's blurry, how could you be sure?
No. There's no, as I say, there's no, it is not put to her before the jury that she's lying. The accuracy of her viewing of the surveillance is not tested.
But that, on one view, is a very significant piece of evidence because that has the two of them at the scene of the offence, does it not? The CCTV footage.
Yes, it places, if she's right, it places the appellant there with the deceased.
Yeah.
Sorting.
And assaulting the deceased.
Yes. Even without, in my submission, that evidence, this is a strong prosecution case, given her evidence as to what she says the appellant said to her and what she saw before the incident in question.
Yes, clearly if you've got two confessions, if they stand up, together with CCTV footage, with recognition of him at the scene of the crime, then it's a strong case. But that may beg the question, why on earth wasn't her evidence being challenged more effectively? Because, I mean, her evidence, the telephone evidence wasn't anything like as central as as her evidence, or putting the accused and the victim together in her apartment, leaving together, then at the scene of the offence, that was perhaps along with the police confession, the critical case.
Well, all I can observe from the transcript is that the appellant clearly considered that the mobile phone evidence was critical.
Yes.
And by establishing with Miss Davis that she would use regularly the phone number that the minutes were transferred to, and then establishing with Mr. Green that mistakes can be made in the transfer of minutes, he clearly saw that as establishing his defence.
I see.
Sorry, and my lady's assisted me with a reference, page 113, someone describing, I think, the CCTV footage, lines 10 to 14.
Yes.
You point out who else is there. This would be the subject in the black top with a white T-shirt underneath, along with a black, appears to be mask, white gloves, dark trousers, appears also to be dark shoes. So, I mean, if that is what the CCTV is showing, there is something of a difference between the initial account given by Ms. Davis of the clothing.
He said he had black shoes and he handed them to the police, didn't he?
The police certainly took a pair of shoes from his apartment afterwards as part of the investigation.
Yes. Well, if it was a view of him from behind, then the black top and the black trousers would tally with the earlier evidence as to what he was wearing at Miss Davis's apartment.
This is Detective Munro giving evidence as to what can be seen from the CCTV. Yes.
But I mean, the white T-shirt may not tally precisely with a beige T-shirt, but so be it.
No, I think that's the.
No, it's the dark shoes
It's
that's
the dark
different.
shoes, yeah.
Because they were white tennis.
Oh, they were white tennis shoes. Yes.
So it's the contrast with page 169, sorry, just to assist you, Mr. Paul.
No,
It was some white tennis, I think, if I could remember. Yes.
Grounds 4 and 5 taken together, Dr. Reddy or the absence of Dr. Reddy. The respondent's two overarching submissions here. First, the report was properly admitted into evidence, and second, the appellant suffered no prejudice when considered in the context of proceedings as a whole. Now, the appellant's case as developed by the written further submissions on grounds 4, 5, 6 that were lodged a couple of days ago expand fairly significantly on the written case before the board. I just mention that because I understand the appellant not to be advancing a case that section 120 of the Criminal Procedure Code is unconstitutional, which perhaps if one read some of the submissions, supplemental submissions, was where they were heading. But I understand that's not the case that's being advanced. If that were the case, then the respondent does say that that is an entirely new argument that was not advanced before the Court of Appeal. And when one applies the principles in the case of Baker and the Queen, Lord Didcot said about exceptional circumstances advancing a new case before the board, not advanced below, we do say that this doesn't fall into that category of case. Because the question of constitutionality of Section 120 is precisely the type of case that the board would benefit from the views of the local court, and also would require some evidence to be led. For example, on policy reasons behind Section 120, which is a unique section. You don't find similar sections in the criminal procedure codes of other Caribbean countries, and certainly not in England and Wales. Recognising the supplemental submissions, it is a point that has not been considered by the board in previous cases. So, having sort of, if you like, outlined an argument I don't need to make, that's what we say. If that was as far as Melenfren goes, I think though, if he limits his case to effectively, the judge was wrong to exercise her discretion to allow in the report, then that's obviously a case that falls within the square four corners of his written case, and one that the respondent is in a position to meet. The facts surrounding Dr. Reddy's evidence being put in to evidence are that Dr. Johnson was examined in chief as to effectively why he was giving evidence rather than Dr. Reddy. And Dr. Johnson said, both at the voir dire and before the jury, that Dr. Reddy had retired and was not in the jurisdiction. So that's the sort of evidential basis. That's how the prosecution sort of explained why Dr. Reddy was not there to give evidence in person. And references for the voir dire are volume 1, 360, lines 28 to 32, and before the jury, volume 2, page 763, lines 16 to 21. The prosecution submissions in the Court of Appeal went arguably slightly further. They confirmed that Dr. Reddy had retired when this was all discussed in oral submissions in the Court of Appeal, and had left the Bahamas. And the reference to that is volume 4, page 1461. And for those reasons, that the judge permitted the report to be read into evidence by Dr. Johnson. It's fair to say, though, that when one looks at the transcript of the trial, there was no discussion as to under which evidential gateway the report was put in evidence. Simply accepted this was acceptable, and as the Court of Appeal in fact say, common practice in the Bahamas. The Court of Appeal's analysis of the situation descends into looking at section 120 of the Criminal Procedure Code, and also section 66 2A Roman 2 of the Evidence Act. And the Court of Appeal was satisfied that the report was properly admitted under both of those provisions. And we see the Court of Appeal's judgment at page 1786 through to 1787, so paragraphs 15 to 19.
Section 120 allows you to put in a record of these various kinds as prima facie evidence.
Yes. Stands effectively as evidence as to what it says on its face. And my understanding of section 120, and this goes to why, if this argument was being made about constitutionality, we would perhaps require some evidence as to the policy behind it, is that it was brought in, I think it was brought in the 1980s, to alleviate pressure on medical practitioners and other experts attending court to have to testify, where the experience of the Bahamian courts was that evidence, often forensic findings, went unchallenged at trial.
So it's not like a hearsay business record, it's slightly different.
It is slightly different. But there is no overarching discretion on the trial judge to exclude evidence if it is unfair to the defendant. There's no question as to that discretion in my submission. And the judge plainly considered that there was nothing unfair in allowing Dr. Johnson to read into evidence Dr. Reddy's report. And I say,
Did the appellant appreciate there was that discretion? Did he make any submissions about it?
he didn't make any submissions, but he was asked. He was effectively asked, told, this is what is about to happen. Do you object? And perhaps understand. He said no.
I rather had the impression that he was given the impression this was all perfectly normal. Did he object?
Yes, that's a fair reading of the exchange. It is, and in my submission, that is when one looks at the Court of Appeal judgment, who says this is common practice in the Bahamas. This is common practice, effectively, for one medical practitioner to read into evidence the report of a colleague, if that colleague is unavailable to attend trial.
There are two things going on. One is that the report is actually being treated as more than prima facie evidence, but that's the report. And the other is that you put another doctor into the witness box to answer any questions, which is, once you get beyond and it's challenged and it's not standing well as prima facie evidence, you put somebody there, but it's a different somebody to answer the questions.
Yes. And the point is actually made by the prosecution in the Court of Appeal that they, wrongly, the reason that they invited Dr. Johnson to read into evidence Dr. Reddy's report was so that the appellant would not be disadvantaged. Otherwise, they would have simply put in Dr. Reddy's report. It was the prosecution's submission in the Court of Appeal. And so they considered that they were providing the appellant an opportunity to put to Dr. Johnson such points that he wanted to about medical issues arising from the report. Because I take my Lady Black's point that was made to my learned friends, which is this isn't squarely an expert. This is also Dr. Reddy could give evidence of fact. And in fact, that's really all that the appellant, my submission, can point to by way of prejudice, because the only thing that, and there's an exchange in the Court of Appeal with leading counsel for the appellant, where the Court of Appeal effectively say to him, it's all well and good saying you've been prejudiced, but identify for us some prejudice, and identify to us what questions the appellant says he would have put to Dr. Reddy that he can't and didn't put to Dr. Johnson. And at that stage, leading counsel for the appellant says, effectively, you have my submissions and can't identify it. Now, obviously, we can identify something. The appellant was denied the opportunity of putting to Dr. Reddy, I told you X, Y, Z, but it's not in your report. Why is it not in your report? That was considered by the Court of Appeal, and we see this in the, the President posed this question for himself, and the reference to the exchange is at Volume 4, 1718, 1728. And I say, what is said there is fair, because the appellant reports to Dr. Reddy that he has been beaten with a baseball bat and kicked in the chest, and that is recorded by Dr. Reddy in his report. And we see that in the report, it's page 365, volume 1. Dr. Reddy reports that he finds 2 superficial scratches and says the rest of the examination was unremarkable. That, in my submission, is what is to be inferred from that is all that Dr. Reddy found, and that the allegation that the claimant was beaten with a baseball bat and kicked in the chest is entirely inconsistent with the findings of superficial scratches that was noted by Dr. Reddy.
But if you had had Dr. Reddy there, you could have put, don't you remember that when you felt my chest there was a raised area? Don't you remember I called out from pain, etc., etc.?
I entirely accept those questions could have been and could have been properly put to Dr. Reddy. But say when one looks at the report and what he has found in the context of a report of being beaten with a baseball bat and kicked in the chest, would Dr. Reddy, is the likelihood that Dr. Reddy would have said anything different from what was in his report?
Well, on that basis, we wouldn't be cross-examining many people, would we? I mean, that's...
And might it not be said that it's actually a highly prejudicial report for the very reason that you're giving? It goes in unchallenged, seems to be directly supportive of the police witnesses in the evidence that they're giving, which is subject to challenge.
But, I mean, save for the point by Lady Black to me, which is the line of cross-examination that goes, don't you remember when I complained about X, Y, Z, why isn't that in your report? Potentially would go some way. The appellant cross-examines Dr. Johnson very effectively on the scratches and the superficiality of the scratches and what's in Dr. Reddy's report, to the extent that the Court of Appeal identify that fairly extensive cross-examination of Dr. Johnson by the appellant as a very good example of him putting his case clearly and cogently.
Right, but to the wrong person. I mean, if one's being pejorative about it, he's not able to put his case to the doctor that actually examined him, and he's doing the best he can with someone that wasn't there.
It would certainly be to the wrong person, and he would not be able to put the I reported to you this and that, because it's not that doctor. But he can, of course, cross-examine Dr. Johnson about Dr. Reddy's medical findings and make such points that he did, which is, for example, given my build, is it not possible that you would not, as a doctor, record injuries to the chest, despite me having received a beating with a baseball bat or being kicked in the chest? So, and they are perfectly proper questions to put to a medical practitioner commenting on cause of injuries and what's been recorded by Dr. Reddy. And that's what the appellant cross-examines Dr. Johnson fairly extensively about and fairly effectively in my submission.
Yes, thank you.
And in answer, and just really to confirm my Lord James's question to my own friend about the directions given to the jury in summing up, it is quite right to say that the judge does not identify specifically that any prejudice that the appellant has suffered by not having Dr. Reddy there in person. There are standard directions given about expert evidence and the jury not having to accept such evidence, even if it is not challenged, and that's at volume 3, 1216, line 31.
Sorry, the reference again.
Sorry, volume 3, page 1216. It is highlighted that Dr. Reddy did not come to court to give you the evidence that the judge has just outlined, and that's at page 1217. And then the judge reminds the jury of the appellant's evidence and the significance of what the appellant says the superficiality of the injuries to his wrists is. Ground 6, we deal with, in our written case, paragraphs 54 to 59. Ground 7, which is to do with the credibility of Miss Davis, we deal with paragraphs 60 to 61 of our written case. Ground 8, the lack of corroborative evidence, we deal with at 62 to 63. And then ground 9, the proviso, at 64 to 65. And really just one point, and it's the point that's made in our written case on the proviso. This is a case where the Court of Appeal said if they are wrong about any of their findings, then this is a case in their mind where it would be appropriate to apply the proviso. And simply draw the board's attention to what is said in the case of Stafford, which is tab 23, electronic bundle 2345, and it's Lord Hope in Stafford at page 2348, that the board should not readily interfere with the local exercise of the proviso. So there, the respondent's submissions in answer to the grounds of appeal against conviction. I can deal then with sentence.
Just before you move on, just on the lack of corroborative evidence point,
Yes.
which I think is ground 8.
Ground 8, yes.
Does that link to the possibility of challenge to the evidence of Zena Davis? Because on my understanding, it was a criticism that it wasn't possible, in effect, to check her account because the physical evidence hadn't been gathered by the police. Is that right?
Well, I don't say that's an incorrect summary of what the appellant's saying. If I say that, if that is what they're saying, then I say that it's unfounded because there are numerous examples in the record of the police carrying out proper investigations. And so, for example, I think it's said by the appellant that the police didn't look for the knife, didn't look for the car, effectively did not do anything. Well, I say that's wrong. Officer Evans' evidence was that they tried to find the knife but couldn't find it. And the reference for that is volume 1, page 305, lines 1 to 9, and volume 2, page 559. And I suppose a point to be made here is that this is slightly inconsistent with the appellant's evidence about being framed, because the appellant effectively said, I told the police where they'd find the knife, took the police there and they didn't find the knife. Prosecuting counsel also confirmed that the police had looked for the appellant's car but had not been able to find it. That's volume 4, page 1763. And the appellant makes quite a lot in their written case of there's a repeated reference to the appellant's clothes and gloves not being found. Well, if what the appellant says in his confession statement is right, then that's hardly surprising, because in his confession statement he said that he burned them because they were covered in blood, where the Haitians sort of burn things was his evidence, which is volume 2, page 654, lines 22 to 28.
Thank you.
There are four grounds of appeal on sentence. The third ground of appeal, the board will have seen from our written case, we concede that a period of 3 years and 4 months should be deducted from the appellant's sentence. So ground 3, in that limited extent, is conceded. Ground 1 is the complaint that the appellant was not heard on the length of sentence. Ground 2 is lack of reasons, and then ground 4 is, if I can call it, the constitutionality of the sentence argument. Ground 1 first, we say there are two answers to this ground, and we deal with this at paragraphs 74 to 79 of our written case. Now, first, I say that the appellant was given the opportunity before the trial judge to address length of sentence, but we accept that that was in the context where the judge was operating on the basis that it was that she was not going to impose a determinate fixed length sentence. But we make that point really to meet a point that was made by the appellants, which is that there were no representations at all made on his behalf about length of sentence. The second point, we say no injury has been suffered, as there are no submissions that could have realistically been made on his behalf that could have reduced the sentence. And the no injury argument, to make good that submission, we cite the case of Moss, because we say we are within the category of case that Moss was considering. And Moss is at tab 37, volume 3, electronic bundle 2717. And we accept what was accepted by the Crown in Moss, that the appellant was not asked to make submissions on the appropriate length of sentence in the Court of Appeal, and he ought to have been. Now, Moss was a case, again from the Bahamas, where the conviction of murder was to one of manslaughter. And I say that that is important in the present case. If I can ask the board to have open page 2721.
Got a problem, I'm afraid. I don't seem to have volume 3 of the authorities. Oh, wait a minute. I do.
So it's
2717.
under tab 37 is Moss.
Thank you.
And it's 2721.
Thank you.
Picking it up at paragraph 8, the board accepts the submission of Mr. Rowe for the Crown. There may be cases in which, despite a breach of this duty by the court, a reviewing court can be confident that no injury can have been done to the defendant because no submissions that might have been made on his behalf could have reduced the sentence below that passed. And then Lord Hughes goes on to say, but in a serious case of homicide, such as the present, and especially where a long sentence has been passed, which has some time to run, the board would need to consider long before reaching such a conclusion. It's just pausing there. I hopefully make the realistic concession that we are within that category of case. This is a serious case of homicide. A long sentence has been passed, and it has some time to run. Paragraph 9, Lord Hughes outlines reasons for reaching the conclusion in the case of Moss, that the appellant here had suffered injury. Second line, para 9, the defendant was and is entitled to address the proper factual basis for sentence now that the conviction for murder has been quashed. He's entitled to address the relative roles of the two accused, entitled to address the proper tariff for manslaughter, proper place within the tariff for the present offence, and the effect of his lack of previous convictions. All these are properly matters for the Bahamas court, not for the board. And
so those seem to be particular reasons in that case why the opportunity should have been given. But do you want to say anything further about the last sentence of paragraph 8? Because that seems to be the board indicating that especially where you have very long sentences, it's important that people be given an opportunity to make representations.
Accept that, and I say we are squarely within that category of case where this is a serious case of homicide and a long sentence has been passed with a long time to run.
Right.
What I submit, though, to distinguish this case from Moss, because one still then has to, even in those cases, and the board, as Lord Hughes says, will need to consider long before concluding no injury. I accept that. But I say here, there is nothing that could be said that had not been said on the factual basis for sentencing. And so I draw a distinction between the factual basis for sentencing, to use the word Lord Hughes, and the proper place on the tariff. And I'll deal with those separately because I accept that there were no submissions made by this appellant as to where in the 30 to 60 year tariff this offence should lie. I accept that because
it's a huge range.
Well, and I come to that. Dealing with the factual basis for sentencing, there was a full sentencing hearing which considered all of the relevant mitigating factors and the aggravating factors. And they are summarised in the Court of Appeal judgment at paragraph 38. So in terms of mitigation, the Court of Appeal take into account that this is an appellant that owned his own business, had no prior criminal record, a good prison record, no mental illness or delusional thinking, and that character witnesses had described him as hard-working, mannerly, helpful and non-violent. Then list the aggravating factors at paragraph 40 of their judgment, that this was a very serious and violent offence. There was premeditation, as the deceased was lured to his death by sending of text messages pretending to be someone that the appellant wasn't. There was a murder during the course of robbery involving the victim. The deceased was stabbed 10 times and his throat severed nearly 2 inches deep. And despite overwhelming evidence, there was a lack of remorse. So they identify all in my submission that could be said on behalf of the appellant in terms of mitigation and properly identify the relevant aggravating. So unlike Moss, there was nothing in my submission that could have been said regarding the factual basis for sentencing that was not taken into account. Contrast with Moss, where conviction to manslaughter, the fact that there were co-accused, there was alcohol potentially involved, there is a lot that obviously could be said on behalf of the appellant in Moss that had not been said on the basis of the factual basis for sentencing. The proper place in the tariff. No submissions were made on this. The Court of Appeal, though, it is clear from their judgment, were fully aware of the appropriate tariff, and they directed themselves to the relevant cases of Poitiers and Jones, and the board has those at tab 38 and tab 32 of the bundle. And the Court of Appeal explains that having regard to those cases outlining the tariff of 30 to 60 years and taking into account the aggravating and mitigating factors, 55 years is an appropriate sentence. So I say this is a case, to use Lord Hughes's words in Moss, where although the board will have to think long, say the board can be satisfied that no injury has been suffered by this appellant by submissions not being heard by the Court of Appeal prior to sentencing him to 55 years. The second ground is lack of reasons, and really the board has heard me on what I say about that, because I say the Court of Appeal gave sufficient reasons by explaining the basis on which it was sentencing to 55 years. And when I say by explaining the basis, I mean by recording what the aggravating factors were, what the mitigating factors were, the cases of Poitiers and Jones, and why they considered 55 years was the appropriate sentence within that range. And you have a point that's made in our written case, the case of Lang, which is at tab 18, 2270, which is it's always at the discretion of the court as to how much needs to be said, and the test and the guiding principle is one of fairness. So the question is, does the appellant come away being assured that his case has properly been considered? And I say, when you read the Court of Appeal judgment and what they say and the factors they take into account, this is not a case of insufficient reasons. Ground 4, final ground. I think the way we put it, the way the respondent puts it, is if the board consider there is any merit in the argument that this is an unconstitutional sentence, not unconstitutional per se, but unconstitutional in the case of this appellant because of his age when it was passed. If the board considers any merit in that, then the appropriate disposal is remission to the Court of Appeal, because let's accept that these weren't arguments that would run below, and this is again similar to the section 120 CPC point. This is a point that we say the board would benefit from the knowing the views of the local Court of Appeal. We do, however, say on its merits it should be dismissed, because we do say that this is a sentence that is reducible. We say reducible de jure and reducible de facto. And if we're right about that, we say the appellant's argument for unconstitutionality doesn't effectively get off the ground. And we say that based on the case of Lendor, Kefkaris and Wellington, and the board has these submissions in our written case. Unless, my lord, my lady, I can be of any further assistance, there are submissions on conviction and sentence.
Thank you very much. Mr. Fitzgerald, are you going to... Thank you.
Well, just very briefly, if we go back to the points I sought to make, the no attempt, firstly, that there was no attempt to reason with him so as to, or with counsel so as to get the set of papers, we say that still applies. There really was no attempt to say, well, if this is really the problem, you haven't got a set of papers, let's see if we can solve that problem. Secondly, no counselling as to the gravity of the step. The judge later on says that she has done that, but I can see no reference in the key passages to the judge saying, you should stop and think this would be a very grave and prejudicial step to take. The third one, whether she attempted to persuade counsel to stay, we respectfully submit she made no attempt whatsoever to try to persuade counsel to stay, and my learned friend hasn't suggested that. Just his point is that, well, it wouldn't have done any good because the relationship had broken down. But we say that is not established on the transcript. It's no good saying, well, there might have been something going on behind the scenes. The task in our respectful submission is to bring matters at least to the surface, at least to say, can you not work together? And then the fourth point, which is really the crucial point in Mitchell and also in Dunkley, is the adjournment so as to get another lawyer to advise. There is no attempt to explore getting another lawyer. And that is something which certainly Maguire reflects, and the authorities, Mitchell and Dunkley, that is something that should be done. Well, if I got you another lawyer, would you be able to work with another lawyer? And then the fifth point, did the judge ask herself whether it would cause prejudice to the defence? There's no evidence that she asked herself that question, and which could be a reason for saying, I simply refuse to accept that you should withdraw to counsel. So we say that it was deeply flawed, the process, and that really means that it wasn't a proper decision and didn't result in a fair trial, given the centrality of the central importance, the fundamental importance of being represented by competent counsel in a death penalty case, which the minority in Robinson stresses. And then on the question of overall fairness, I think the board has our submissions. Firstly, in relation to Zena Davis, my learned friend fairly accepted that she wasn't competently cross-examined, and very limited cross-examination. Can I just highlight the points which we say have not been answered? Firstly, at page 192, the judge stopped the questioning at the voir dire about why she was there. When it was asked, why were you and your cousin, I think it is Tamika, why were you there? Judge says you can't go into that. With great respect, there's just no basis for saying you can't go into that. It's absolutely crucial why they were there, because if they were there as suspects, or she was there as a suspect, then that would be a crucial question. So if represented, counsel would have been able to say, well, he's perfectly entitled to ask that question. Then there's the point that has been put to my learned friend about seeing him being beaten at page 189. That is simply not followed up on, and we say that that was a really crucial point, which would have gone to the voluntariness of the confession. If she had said, "I saw him being beaten up," then that would have gone to the question of oppression, where the prosecution would have to satisfy the judge beyond reasonable doubt that there was no question of being beaten up leading to the confession being made. And then I just make this further point that at the actual trial, it's volume 2, page 469, she makes no reference to him being beaten. So again, if competent counsel would have said, well, what about the fact that you saw him being beaten up? So we do say that was a series of ways in which one can point to prejudice. And the other point that has been made by my lords and my lady is really there was no effective cross-examination of Zena Davis. And really my learned friend has said very little to answer that. Then as to the Dr. Reddy point, can I just make the point that section 120 may have been treated by the judge and the Court of Appeal as just routinely allowing for it. But Stubbs makes it absolutely clear, of course the Court of Appeal decision in Stubbs is later than this, that section 120 should not be read in that way. I've taken the board to paragraphs 167 and paragraph 201, where they make it clear that a judge should exercise their discretion to require a witness, an important witness, that's an expert witness, a material expert witness to attend. And the defendant simply wasn't given any opportunity to address the court on that. It was just said this happens routinely, and you can't object to him refreshing his memory from somebody else's notes. So he was denied the opportunity of questioning, and as my lady put to my learned friend, he was denied the opportunity on the factual basis of saying, well, I told you that this is what happened. I told you about the plastic bag over the head, just as a matter of fact. And so it was left very prejudicial to him. Well, he didn't, the doctor doesn't record, in the notes read out by someone else, doesn't record any reference to the plastic bag being put over the head. Therefore, this isn't a good point. And that the doctor doesn't record any injuries, therefore he didn't suffer any injuries, and no opportunity really to explore what he told the doctor and whether in fact there were signs of being injured. So we do say that we can point to specific examples of prejudice, but in addition we would say that the overriding thing is that he was unrepresented when the issue of whether he should be represented simply hadn't been gone into in a proper way. And there is authority that if you don't get a fair trial in a fundamental way, it's difficult to say that the conviction is safe. I mean, there are authorities both ways on that, except. But we would respectfully say, and I think that the authorities are referred to in the Maguire case, but we would say that it's pretty fundamental that if he hasn't had a fair trial because he's been wrongly deprived of the opportunity to have representation, that the conviction can't be safe and it can't be said that there's no miscarriage of justice. And my learned friend did deal with the question of why Mr. Seymour was sacked, and he referred to the fact that he said, "I'm not competent," at volume 1 at page 52, and it does appear that then the counsel for the DPP then makes reference to conversations that have been had, but none of that is open and transparent. And as my Lord Sales pointed out, the judge didn't seem very bashful at a later stage in cross-examining him about why he had dispensed with his counsel services.
It's quite common, isn't it, in cases where an accused person, or even in a civil case where someone falls out with their counsel, that one isn't open and transparent about precisely what was the cause of the bust-up, as it were. I'm not sure. I mean, I think you're arguing for a counsel perfection. I don't think consistently with legal professional privilege we can necessarily go down that road. But I don't suppose that detracts from your point that the judge's response to the problem didn't come up to the requirements of Mitchell and Dunting.
Perhaps that's the better way. If one looks at it objectively, when the defendant is saying, I'm going to have to go ahead on my own because I can't get the notes, the judge doesn't say, well, if we manage to get you the notes, would that satisfy you? She just doesn't explore that.
Yes.
It's just simply, well, they've given you a lot. They've given your counsel a set of notes. Well, they absolutely had to give the counsel a set of notes. Therefore, you can't expect more. That really, in our respect for submission, is wholly unreasonable. And then as my Lord pointed out, then if one goes on to, well, let's adjourn, let's give you time to reflect on this, and let's see if another would it assist if somebody else came to advise you? Because it's not the case that he'd rejected every lawyer he'd had. He seemed to be satisfied with what Mr. Roberts had asked for, and Mr. Roberts had withdrawn because of another case. So those really are the points we'd respectfully make on those points. And Dr. Reddy, I think I think the board has our submissions, unless I can assist further on that point. We do say that just to adduce important evidence of that sort at the trial without any opportunity to question the maker of that report was unfair. And it's pointed out in the Stubbs case at paragraph 201 that even if someone is not in the jurisdiction, they can give evidence by video link. So that's at paragraph 201 of Stubbs. But actually all that's said is he's not in the jurisdiction and he's retired. Under section 66 you'd have to prove that he's not available, and the test is that you have to go a bit further than just saying he's retired and he's not in the jurisdiction. And certainly once video evidence is available, there's absolutely no reason why, even if they are outside the jurisdiction, they can't be called and give evidence. So really, to my learned friend's response to the constitutional point, which is, there may be special reasons for section 120, the answer in our respect for submission is Stubbs. Stubbs makes it clear that you nonetheless have to make sure that the person has an opportunity to question if they wish to. And nothing was done to alert him of his rights in that respect or to enable him to exercise those rights. And then, my lady, that we say it would be wholly inappropriate in a case where there's been an unfair trial to apply the proviso. It simply wouldn't be a proper exercise of the discretion in our submission. And then on the question of the sentence, can I just briefly address that, my lord, the question of the sentences? So my learned friend says, well, the Court of Appeal, there was a full sentencing hearing. Well, the full sentencing hearing was at trial. And that was where the aggravating and mitigating factors were looked at in the context of whether he should suffer the death penalty or not. There was no full sentencing hearing at the Court of Appeal. There was no sentencing hearing at all at the Court of Appeal in which these matters were weighed. So they were just looking back at what had emerged in the transcript at the trial, where the context and the issue was quite different. And my learned friend says that the Court of Appeal was fully aware of the tariff. They cited Poitiers and Jones. Well, in Poitiers and in Jones, the sentences were 40 years. So how do you get from 40 years to 55 years, other than by some value judgment, the reasons for which are completely unknown? And there was no offer of an opportunity to address the court. The court would have to have been saying, in effect, look, with the range of 30 to 60 years, we think that this is a case which is right at the top of the range. Have you got anything to say to contradict that, given our other sentences in other cases? There's nothing of that, no opportunity to deal with that point was afforded at all. And we say, understandably, because counsel was effectively saying, we invite you to find that the mandatory minimum is unconstitutional and therefore to remit that for a proper hearing. And we say that therefore there was a denial of natural justice, and that really nothing that my learned friend has said to seek to distinguish Moss is of any sufficient substance to mean that there was a fair hearing. Well, those are really the submissions I make in this. I can assist.
Thank you.
Oh, yes. I think my learned friend may have referred to the fact that when he, at a later stage, dealt with why he fired his lawyer. Yes, at page 998, I think my learned friend did refer to that. And he was asked about what the reasons why Mr. Seymour no longer represents him. And he said, that's why I had to fire him, because he didn't do what I asked him to do. That was 10 days after the key decision. And the judge says that during the course of that discussion, I told you, I warned you about not doing this, but in fact, if one goes back to the key passages at pages 52 to 54, she doesn't say, I'm warning you that this would be a terrible mistake. So we say that the passage at volume 3, pages 912 to 913, where he gives a later explanation of why he dispensed with his services, is really does not throw light, or throws very limited light, on what happened at the original, when the original decision was taken. Moreover, I would make this point, that my learned friend referred you to volume 3, page 1298, where his probation officer said he prefers to represent himself at the sentencing hearing, but in fact he didn't represent himself at the sentencing hearing. As we know from page 1326, he accepted a lawyer to represent him. And so, as it were, the proof of the pudding's in the eating. He did accept his need for a lawyer, and did permit counsel to address the judge on the sentencing and at some length.
Thank you very much, Mr. Fitzgerald. Well, if I could thank counsel for their focused and helpful submissions, and also thank those behind counsel for the preparation of the papers, which greatly assists us with our task. The board will take time to consider what advice that they will humbly tender to Her Majesty.